The city condemned my worthless historic building after I spent 14 years restoring it. They wrote me the biggest check in county history. The demolition crew showed up at 6:15 on a Thursday morning while I was still drinking my first cup of coffee inside the building I had spent 14 years of my life restoring. I heard the diesel engines rumbling outside and looked through the original 1892 glass windows I had painstakingly preserved to see a yellow excavator rolling down Main Street toward my front door. A man in a hard hat was directing it toward my building like I wasn't standing inside, watching them prepare to tear down everything I had built. My hands started shaking so badly that coffee sloshed over the rim of my mug and burned my fingers. I set the cup down on the restored mahogany counter and walked outside to face what was coming. The foreman handed me a piece of paper that said the city of Bellbrook had condemned my building as structurally unsound and a public safety hazard. The demolition was scheduled to begin immediately. No appeal, no hearing, no chance to save the work that had consumed every dollar I had and every weekend for nearly a decade and a half. I stood there on that sidewalk holding a death warrant for my dreams, while strangers prepared to reduce my life's work to rubble. I bought the Whitmore building in 2009 for $11,000 at a tax auction that nobody else attended. The 3-story Victorian commercial building had been abandoned since 1987, when the last business, a hardware store, finally closed its doors after the big box stores opened on the highway outside town. The roof leaked in 17 places I counted that first day. The floors sagged so badly in some spots that you could roll a marble from one end of a room to the other without pushing it. Pigeons had colonized the entire third floor and left decades of droppings covering what had once been a beautiful ballroom with 20-foot ceilings and original plaster medallions. The city inspector who met me there before I signed the papers told me I was throwing my money away. He said the building should have been torn down 20 years ago, and the only reason it was still standing was because nobody wanted to pay for the demolition. He said I would spend more money trying to fix it than the entire block was worth. I thanked him for his opinion and signed the papers anyway because I saw something he could not see. I saw the hand-carved limestone facade that master craftsmen had created before the age of machines. I saw the original tin ceilings hidden under water-stained drop panels. I saw iron columns and heart pine floors and leaded glass transoms that represented an era of craftsmanship that could never be replicated at any price. My name is Raymond Okonkwo, and I grew up in a family of builders. My grandfather immigrated from Nigeria in 1962 and started a masonry business that my father expanded into general contracting. I learned to lay brick before I learned to drive. I understood load-bearing walls and foundation footings the way other kids understood video games. When I graduated from the State University with a degree in architectural preservation, my father told me I was wasting my education on old buildings that should be replaced with something modern and efficient. He said preservation was a hobby for rich people who wanted to feel cultured, not a career for someone who needed to make a living. I worked for 7 years at a preservation architecture firm in the city before I burned out on projects where wealthy clients wanted historic character without any of the inconvenience. I wanted to save a building that nobody else thought was worth saving. I wanted to prove that craftsmanship and history had value even when the market said otherwise. The Whitmore building was everything I had been looking for since I first fell in love with old buildings. As a child, watching my grandfather carefully restore century-old chimneys that lesser masons would have torn down and rebuilt from scratch. The first 3 years were nothing but stabilization work that nobody could even see when it was finished. I spent every weekend jacking up sagging floor joists and sistering new lumber alongside the original heart pine beams. I replaced 18 sections of foundation where the limestone had deteriorated below grade level. I installed a new roof membrane over the original slate to stop the leaks without destroying the historic roofline. I rewired the entire building to modern code while carefully preserving the original knob and tube wiring as a museum piece inside glass display cases I built into the walls. I replumbed with copper, restored the original radiator heating system, and brought the structure up to every safety standard the building code required. None of this work was visible from the street. The building still looked like a condemned eyesore because I had not touched the facade or the windows or any of the decorative elements that people actually noticed. I was building from the inside out because that was the only way to do preservation right. You had to make sure the bones were sound before you worried about the skin. My father came to visit once during this phase and shook his head at what he called my folly. He asked what I was trying to prove, and I told him I was trying to prove that some things were worth saving, even when saving them made no economic sense. The city started paying attention to my project around year 4 when I began the exterior restoration. I stripped the aluminum siding some previous owner had installed in the 1960s and revealed the original red brick beneath. The brick needed repointing, which meant carefully removing the deteriorated mortar joints and replacing them with new mortar mixed to match the original lime-based formula. Modern Portland cement mortar would have been faster and cheaper, but it would have trapped moisture inside the brick and caused spalling within a decade. I spent 14 months repointing by hand. Working from scaffolding, I built myself on weekends and evenings after my day job at a local construction company. The building inspector came by during this phase and watched me work for almost an hour without saying anything. His name was Dale Kramer, and he had been inspecting buildings in Bellbrook for over 30 years. He finally told me that he had never seen anyone put this much work into a building the city had written off as unsalvageable. He said he respected what I was doing, even if he thought I was slightly crazy. I told him the only crazy thing was letting buildings like this disappear because nobody was willing to do the hard work of saving them. He laughed and said he hoped I proved him wrong about the building's future. By year 7, I had moved into the 3rd floor and was operating a small architectural preservation consulting business from the 2nd floor, while the ground floor remained under construction. The ballroom upstairs was now my living space, with the original plaster medallions cleaned and restored, and the heart pine floors refinished to a warm honey glow. I had converted half the space into a bedroom and kitchen area while preserving the other half as an open, entertaining space with its original 12-foot windows overlooking Main Street. The city planning department contacted me that year about participating in a downtown revitalization study. A woman named Commissioner Diane Ashworth called me personally to say the city was impressed with my restoration work and wanted to feature the Whitmore building in their promotional materials. She asked if I would be willing to serve on an advisory committee for historic preservation. I said yes, because I thought the city was finally recognizing the value of saving its architectural heritage. I had no idea that Diane Ashworth was playing a much longer game that would nearly destroy everything I had built. The revitalization study turned into a comprehensive downtown master plan that the city released in year 9 of my restoration. The plan called for demolishing most of the historic buildings on Main Street and replacing them with a mixed-use development featuring modern retail, parking structures, and luxury apartments. The Whitmore building sat in the exact center of the proposed development footprint. I attended the public hearing where the plan was presented and listened to city officials describe my neighborhood as blighted and economically unviable. They showed renderings of glass and steel towers where my building currently stood. They talked about increased tax revenue and job creation and economic development. They never mentioned that a private developer named Preston Hargrove had already been selected to build the project and that he happened to be Commissioner Ashworth's former business partner from a real estate venture they had operated together in another state before she entered public service. I learned that detail 3 months later from a journalist named Marcus Finley, who had been investigating Ashworth's background for an unrelated story and stumbled across the connection while reviewing corporate filings. I started attending every city council meeting after the master plan was released. I spoke during public comment periods about the historic and architectural significance of the buildings the city wanted to demolish. I brought photographs showing the craftsmanship that would be lost forever. I presented economic studies proving that historic preservation generated more tourism revenue and created more jobs than demolition and new construction. I organized a group of business owners and residents who opposed the plan. We called ourselves the Bellbrook Heritage Alliance, and we collected over 2,000 signatures on a petition asking the city to reconsider the demolition strategy. Commissioner Ashworth smiled at me during meetings and thanked me for my passionate advocacy while making clear that the city's decision was final. She said progress required difficult choices and that we could not let nostalgia prevent the community from reaching its economic potential. She said the buildings on Main Street were too far gone to save, and that demolition was the only responsible option. When I pointed out that my building was the proof that restoration was possible, she said my situation was unique and could not be replicated across an entire commercial district. I watched her deliver these dismissals with a politician's practiced sincerity and felt my stomach tighten with the certainty that she was lying about something I could not yet prove. The harassment started small in year 10. Building Inspector Dale Kramer retired and was replaced by a man named Victor Fontaine, who seemed determined to find violations in my completed restoration work. He cited me for electrical code issues that the previous inspector had already approved. He claimed my fire suppression system was inadequate even though it exceeded current requirements. He said my certificate of occupancy should never have been issued and threatened to revoke it if I did not address a list of deficiencies that would cost over $80,000 to correct. I hired a code compliance attorney named Theodore Nash, who specialized in fighting municipal overreach. Theodore was 63 years old with gray hair and a quiet intensity that made opposing attorneys nervous. He reviewed the inspection reports and told me that every citation was either fabricated or based on misinterpretations of code language that any competent inspector would recognize as wrong. He said the pattern suggested someone was directing Fontaine to create problems where none existed. He filed formal appeals on every citation and requested all communications between the building department and the city manager's office regarding my property. The city denied the records request, claiming executive privilege. Theodore said that denial told him everything he needed to know about who was orchestrating the campaign against me. The appeals process dragged on for 18 months, while Victor Fontaine continued finding new violations every time he visited my building. He cited me for handrail heights that were off by a quarter inch. He claimed my exit signs were mounted too high, even though they were at the exact height specified in the fire code. He said my window restoration had created structural deficiencies because I used traditional glazing methods instead of modern sealants. Every citation required a formal response, documentation, and legal fees that were draining my savings faster than I could replenish them. I was spending more time fighting the city than running my business, or finishing the restoration work that still needed to be done on the ground floor. My girlfriend at the time, a woman named Keisha, who had supported me through years of dusty weekends and delayed vacations, finally told me she could not watch me destroy myself over a building anymore. She said I had become obsessed with a fight I could not win against people who had more resources and more power than I would ever have. She moved out on a Sunday afternoon while I was at a city council meeting arguing about zoning variances. I came home to a half-empty apartment and a note saying she hoped I would find whatever I was looking for, but she could not wait any longer to find out if I ever would. The condemnation notice arrived on a Wednesday morning in year 14. Victor Fontaine delivered it personally with 2 police officers standing behind him as witnesses. The notice stated that the Whitmore building had been determined to pose an immediate threat to public safety, based on structural deficiencies identified during a recent engineering assessment. The city was exercising its emergency condemnation authority to require immediate demolition. I had 72 hours to remove my personal belongings before the building was secured. There was no appeal process for emergency condemnations. The decision was final. I stood in my doorway holding the paper and felt my legs go weak beneath me. 14 years of my life reduced to a single page of bureaucratic language that gave me 3 days to say goodbye to everything I had created. I asked Fontaine, who conducted the engineering assessment. He said that information was confidential. I asked to see the assessment report. He said I could file a public records request after the demolition was completed. I asked him how the city could demolish a building without showing the owner the evidence justifying the demolition. He smiled and told me that was above his pay grade. He said I should focus on packing. Theodore Nash filed an emergency motion for a temporary restraining order within 4 hours of my phone call. He argued that the city was violating my due process rights by condemning my property without providing the underlying evidence or any opportunity to challenge the findings. Judge Patricia Oyalaran of the County Circuit Court scheduled an emergency hearing for the following morning. I spent the night photographing every inch of my building and documenting the restoration work I had completed over 14 years. I pulled out every inspection report, every permit, every certificate showing that the building met or exceeded all applicable codes. I gathered structural engineering assessments from 3 independent firms who had evaluated the building during my restoration. I barely slept because I was terrified that the city would send the demolition crew before the court could intervene. Theodore called me at 5 in the morning to say he had arranged for a process server to deliver the restraining order motion directly to the city attorney's office the moment the doors opened. He told me to meet him at the courthouse at 8 and to bring every document I had ever received about my building. He said we were about to find out whether the rule of law still meant anything in Bellbrook. The courtroom was standing room only when Judge Oyalaran took the bench. Word had spread through the Heritage Alliance network, and dozens of supporters showed up to watch the hearing. The city was represented by their chief litigation attorney, a woman named Sandra Huffman, who had a reputation for aggressive tactics and a perfect record in municipal court proceedings. She argued that the city had broad authority to protect public safety and that requiring evidentiary hearings before emergency condemnations would create dangerous delays when buildings posed imminent threats. She said my building had been assessed by a licensed structural engineer who determined the foundation was failing and the walls could collapse at any time. She said the city could not risk innocent people dying while lawyers argued about procedure. Theodore stood up and asked a simple question. He asked to see the engineering assessment. Sandra said it was a confidential work product protected by attorney-client privilege. Theodore pointed out that the assessment was the sole basis for condemning my property and that denying me access to see it was a fundamental violation of due process under both the state and federal constitutions. Judge Oyalaran leaned forward and asked Sandra if the city was seriously arguing that it could demolish a citizen's property based on a secret document the citizen was never allowed to see. Sandra said the city was acting in good faith to protect public safety. The judge asked again if the city would produce the document. Sandra said she would need to consult with her client. Judge Oyalaran granted the temporary restraining order blocking any demolition while ordering the city to produce the engineering assessment within 48 hours. She said the court was deeply troubled by the city's position and warned that any attempt to proceed with demolition in violation of the order would result in contempt charges against every official involved. I walked out of the courthouse feeling like I could breathe for the first time in days. Theodore put his hand on my shoulder and told me not to celebrate yet. He said the city would produce some document, and we needed to be ready to challenge whatever they came up with. He said Sandra Huffman did not lose cases, and she would not stop until she found a way to take my building down. He was right about that. What neither of us expected was how far the city would go to manufacture the justification they needed. The engineering assessment arrived at Theodore's office 46 hours after the court order. It was dated 2 days before the condemnation notice was issued and was signed by a structural engineer named Gerald Ostrowski, who I had never heard of. The report claimed that the foundation was experiencing catastrophic failure, that the load-bearing walls were compromised by water infiltration, and that the building could collapse without warning at any time. It recommended immediate demolition as the only safe remediation option. I read the report 3 times looking for anything that resembled the actual condition of my building. The foundation I had spent 3 years reinforcing and waterproofing. The load-bearing walls I had personally inspected and documented with photographs every 6 months for over a decade. The building that 3 independent structural engineers had certified as sound during my restoration. Either Gerald Ostrowski was completely incompetent, or he had never actually set foot inside my building. Theodore hired a private investigator named Lena Blackwood to look into Ostrowski's background and the circumstances of his assessment. Lena had spent 15 years as an FBI forensic accountant before going private, and she had a talent for following money through complicated corporate structures. She charged $500 a day plus expenses and told me up front that she would need at least 2 weeks to do a thorough investigation. I told her to take whatever time she needed because I was not going to lose my building to a fraudulent report. Lena's preliminary findings arrived 8 days later in a manila envelope that would change everything. Gerald Ostrowski was a licensed structural engineer in the state, but his license had been suspended twice for ethics violations involving falsified inspection reports. He had been reinstated both times after paying fines and completing remedial ethics training. More importantly, Ostrowski's engineering firm had done consulting work for Preston Hargrove's development company on 6 projects over the past 4 years. The same Preston Hargrove who stood to profit from demolishing my building and the rest of Main Street. The same Preston Hargrove who had a documented business relationship with Commissioner Diane Ashworth. Lena traced payments from Hargrove's company to Ostrowski's firm, totaling over $400,000 since 2019. She found emails and public records requests from other jurisdictions showing that Ostrowski had provided favorable engineering assessments for Hargrove projects that later failed inspections by other engineers. The pattern was clear. Ostrowski was Hargrove's paid expert who could be relied upon to produce whatever conclusions the developer needed to advance his projects. The condemnation of my building was not about public safety. It was about removing the last obstacle to a development deal that would make powerful people very wealthy. Theodore filed a motion to dismiss the condemnation based on fraud and conflict of interest. He attached Lena's report and demanded that the city disclose all communications between city officials, Preston Hargrove, and Gerald Ostrowski regarding my property or the downtown development project. The motion was a bomb thrown into a quiet room. Within hours, local news reporters were calling my phone, asking for comment on allegations that the city had conspired with a private developer to illegally seize historic properties. A television station sent a crew to film my building while a reporter did a stand-up talking about corruption in City Hall. Commissioner Ashworth issued a statement calling the allegations baseless and politically motivated. She said the city was simply trying to protect public safety, and that malicious accusations from disgruntled property owners would not deter elected officials from doing their jobs. She said Theodore Nash was a known troublemaker who made his living filing frivolous lawsuits against municipal governments. She did not address any of the specific evidence Lena had uncovered or explain her prior business relationship with Preston Hargrove. The city's response to our motion arrived 2 weeks later, and it was unlike anything Theodore had seen in 30 years of practice. Instead of defending the condemnation, the city announced that it was withdrawing the emergency order and would pursue traditional code enforcement procedures instead. Sandra Huffman filed a brief arguing that the case was now moot, since the city was no longer seeking emergency demolition. She asked the court to dismiss all pending matters and deny our request for document discovery as no longer relevant to any active proceeding. It was a tactical retreat designed to avoid producing the communications that would prove the conspiracy. Theodore saw through it immediately and filed a motion arguing that the city could not escape accountability by simply withdrawing its unconstitutional action. He cited federal civil rights law, allowing citizens to recover damages for constitutional violations even after the government stopped the offending conduct. He argued that the city's pattern of harassment, culminating in the fraudulent condemnation, entitled me to compensation for the harm I had suffered and to injunctive relief preventing future abuse. Judge Oyalaran scheduled a hearing on the competing motions for the following month. I was sitting in my office on the second floor when the building shook hard enough to knock books off my shelves. It was a Thursday afternoon around 3 o'clock, and my first thought was earthquake, even though earthquakes were almost unheard of in this part of the country. Then I heard the screaming metal and the crash of masonry, and I ran to the window facing the rear alley. A backhoe was tearing into the building adjacent to mine, the old merchant hotel that had been vacant since I first came to Bellbrook. Nobody had told me there was scheduled demolition work next door. Nobody had warned me that heavy equipment would be operating feet from my foundation. I called Theodore while I was running down the stairs, and he told me to document everything with photos and video before the equipment could be moved. I burst out the back door and found the backhoe operator pulling down the merchant hotel's rear wall while debris rained onto my property. I screamed at him to stop, but he either could not hear me over the engine noise or did not care. A section of brick wall crashed into my restored courtyard, destroying the period-appropriate fountain I had installed and cracking the flagstone paving I had laid by hand over 2 summers. I stood there in the dust and debris recording video on my phone while someone systematically destroyed the space I had created. The demolition foreman finally emerged from a trailer and told me to get off the worksite. I showed him my phone and said I was the owner of the adjacent building and that his equipment was damaging my property. He shrugged and said the city had authorized the demolition and any damage claims should be filed with the appropriate department. I asked him who had authorized starting demolition work without notifying adjacent property owners. He said that was not his problem. He said his job was to tear down the building, and that was what he was going to do. Theodore arrived 40 minutes later and immediately called the city attorney's office demanding an explanation. Sandra Huffman claimed the city had provided proper notice of the demolition through certified mail sent to all adjacent property owners 2 weeks earlier. Theodore asked her to produce a copy of the notice and proof of delivery. She said she would look into it and get back to him. She never did. The certified mail notice she claimed was sent did not exist because nobody had sent it. The demolition was deliberately scheduled without warning specifically to damage my building and create new justification for condemnation. The backhoe operator struck my foundation wall twice before the day was over. Each impact was recorded on the security cameras I had installed years earlier to monitor the building during my absence. The footage showed the operator deliberately swinging the bucket toward my building in movements that could not have been accidental. Theodore obtained a temporary restraining order, halting the demolition before they could do more damage, but the harm was already done. I hired a structural engineer named Dr. Imani Okafor, a professor of civil engineering at the State University with 20 years of forensic experience, to assess the damage. Her preliminary report documented cracks in my foundation wall, damage to load-bearing elements, and compromised waterproofing that would cost over $150,000 to repair. She noted that the damage was clearly caused by impact from heavy equipment and could not have resulted from any pre-existing structural deficiency. She concluded that my building, which had been perfectly sound before the demolition began, now had genuine structural damage that would require significant remediation. The city had manufactured the very condition they falsely claimed existed when they tried to condemn my building. I remember sitting alone in my apartment that night, looking at Dr. Okafor's photographs of the cracks running through my foundation. 14 years of work, every dollar I had ever saved, every relationship I had sacrificed, every weekend and holiday I had spent covered in plaster dust and wood shavings. All of it now genuinely threatened by damage that corrupt officials had deliberately inflicted to justify their predetermined conclusion. I called my father for the first time in months and told him what was happening. He listened without interrupting while I explained the conspiracy, the fraudulent engineering report, the demolition without notice, the damage to my foundation. When I finished, he was quiet for a long time. Then he said something I will never forget. He said he had been wrong about old buildings. He said he understood now that I was not trying to preserve bricks and mortar. I was trying to preserve something about who we are as people, about the value of craftsmanship and the importance of honoring what came before us. He said he was proud of me for fighting even when the fight seemed impossible. He asked what he could do to help. I told him I needed money for legal fees and structural repairs. He said he would mortgage his house if necessary. I told him that was not what I meant, but I heard the determination in his voice, and I knew he would do it anyway. Theodore assembled a legal team for what he called the most important municipal corruption case of his career. He brought in a civil rights attorney named James Quartermain, who had won 2 cases before the federal appellate court involving unconstitutional property seizures. He retained a forensic accountant to trace the financial connections between city officials, Preston Hargrove and Gerald Ostrowski. He hired a media consultant to manage the growing press interest in the case. The team worked for 3 weeks preparing a federal civil rights lawsuit against the city, Commissioner Ashworth, Victor Fontaine, and Preston Hargrove personally. The complaint alleged conspiracy to deprive me of my constitutional rights, fraud, tortious interference with property rights, and intentional infliction of emotional distress. It sought compensatory damages for the harm to my building and business, punitive damages to deter future misconduct, and attorney's fees under the federal civil rights statutes. Theodore warned me that the city would fight back hard and that the litigation could take years. He said I needed to be prepared for a long war of attrition designed to exhaust my resources and my will. I told him I had been fighting for 14 years already, and I was not going to stop now. The discovery phase revealed the full scope of the conspiracy. Theodore's team obtained over 4,000 pages of emails, text messages, and internal documents through court-ordered subpoenas. The communications showed that Commissioner Ashworth had been discussing my building with Preston Hargrove since year 8 of my restoration, 3 years before the downtown master plan was publicly announced. They had identified my property as the key obstacle to the development project because I was the only owner on Main Street who was actively investing in preservation rather than waiting for a buyout offer. Hargrove's emails to Ashworth described me as a problem that needed to be solved and discussed strategies for pressuring me to sell or abandon the building. Ashworth responded with suggestions about using code enforcement to create financial pressure and mentioned that she knew someone who could help with engineering assessments if needed. That someone was Gerald Ostrowski, who had done work for Hargrove on previous projects where inconvenient property owners needed to be removed. The documents showed a years-long campaign to drive me out of my building using every tool of government power available to corrupt officials. Victor Fontaine's communications were even more damning. His emails with city administrators showed that every inspection finding and code citation was directed from above. He was told what violations to find before he ever visited my building. He was instructed to focus on interpretive issues that were difficult to challenge and to avoid anything that could be easily disproved. When he complained that my building was actually in excellent condition and he was having trouble finding legitimate problems, his supervisor told him to look harder or find a new job. Fontaine had a pension coming in 3 years, and he chose to follow orders rather than risk his retirement. His testimony would later become key evidence because he broke down on the stand and admitted everything when James Quartermain confronted him with his own emails. He said he knew what he was doing was wrong, but he felt trapped between his conscience and his financial security. He said he was sorry for what they had done to me. The apology did not restore the years of stress and expense his fraudulent citations had caused, but it did provide a clear admission of liability that made the city's legal position untenable. The trial lasted 3 weeks in federal district court before Judge Malcolm Sterling, a Reagan appointee with a reputation for strict adherence to constitutional principles and deep skepticism of government overreach. Theodore and James presented a meticulous case documenting every step of the conspiracy, from the initial discussions between Ashworth and Hargrove through the fraudulent condemnation and the deliberate damage to my foundation. They called expert witnesses who testified that the city's actions had no legitimate public safety justification and were designed solely to benefit private interests. They showed the jury photographs comparing my expertly restored building to the engineering report claiming it was about to collapse. They played the security camera footage of the backhoe operator deliberately striking my foundation wall. They traced the money flowing from Hargrove to Ostrowski and the communications proving that Ashworth had orchestrated the entire scheme while pretending to be a neutral public servant. The defense tried to argue that officials were entitled to qualified immunity and that any mistakes were made in good faith, pursuit of legitimate government objectives. Judge Sterling was visibly skeptical of these arguments and sustained most of Theodore's objections to the city's evidence. Commissioner Ashworth took the stand on day 12, and her carefully constructed public image crumbled under James Quartermain's cross-examination. He walked her through her own emails line by line, asking her to explain what she meant when she called me a problem that needed to be solved. He asked why she never disclosed her prior business relationship with Hargrove during any public discussion of the downtown development. He asked whether she had personally directed Victor Fontaine to find code violations in my building. She denied everything at first, claiming the emails were taken out of context and that she had simply been doing her job as a commissioner. Then James showed her a text message she had sent to Hargrove on the day the condemnation notice was issued. The message said, "Finally got the old man out. Now you can move forward with the project." Ashworth stared at the text displayed on the courtroom monitors and could not explain how that message reflected anything other than personal involvement in an illegal scheme to seize my property for private benefit. Her attorney objected and requested a recess, but the damage was already done. The jury had seen a public official caught in an undeniable lie about her role in destroying a citizen's property rights. The jury deliberated for less than 6 hours before returning a verdict in my favor on all counts. They found that the city, Commissioner Ashworth, Victor Fontaine, and Preston Hargrove had conspired to violate my constitutional rights through a pattern of harassment, fraud, and abuse of government power. They awarded compensatory damages of $2.3 million for the harm to my building, my business, and my emotional well-being. They awarded punitive damages of $8.7 million against Hargrove personally and $3.2 million against Ashworth personally, finding that their conduct was malicious and deserving of punishment sufficient to deter similar behavior by other officials. The total judgment of $14.2 million was the largest civil rights verdict in county history. Theodore shook my hand as the verdict was read and told me we had accomplished something that would protect property owners across the state for generations. Judge Sterling commended the jury for their careful attention to the evidence and noted that the case demonstrated the importance of an independent judiciary in checking abuses of government power. He said officials who used their positions to benefit private interests at the expense of citizens deserved the consequences the jury had imposed. The aftermath unfolded faster than anyone expected. Commissioner Ashworth resigned from office 3 days after the verdict, citing health reasons that nobody believed. The state attorney general opened a criminal investigation into her conduct and eventually charged her with bribery, conspiracy, and official misconduct. She pleaded guilty to reduced charges and received a sentence of 18 months in federal prison plus 5 years of probation. Victor Fontaine was fired from the building department and lost his pension when investigators documented years of fraudulent inspections beyond just my case. Gerald Ostrowski surrendered his engineering license rather than face disciplinary proceedings that would have exposed the full extent of his willingness to produce false reports for paying clients. Preston Hargrove's development company collapsed under the weight of lawsuits, and he eventually filed for bankruptcy protection. The downtown development project that was supposed to replace my building and everything around it was permanently abandoned. The other buildings on Main Street still stand today, saved by the same fight that preserved mine. I used part of the settlement money to complete the restoration of the Whitmore building and repair the damage the city had inflicted on my foundation. The ground floor finally opened as the mixed-use space I had always envisioned, with a coffee shop, a bookstore specializing in architectural history, and my own preservation consulting office occupying the storefronts that had been vacant for over 30 years. I established the Bellbrook Heritage Fund with a $2 million endowment to provide grants for property owners who want to preserve historic buildings but lack the resources to fight bureaucratic obstacles. The fund has helped save 14 buildings in 5 counties since it began operating. I hired Lena Blackwood on a permanent retainer to investigate any government official in the region who shows signs of using their position to benefit private developers at the expense of citizens. Her work has led to 3 more corruption investigations and the resignation of 2 other officials who thought they could operate like Ashworth without consequences. My father came to the grand opening celebration and walked through every room of the restored building while I explained the work I had done over 14 years. He stopped in front of the original cast-iron columns I had stripped of decades of paint to reveal their ornate capitals beneath. He put his hand on the cold metal and stood there for a long time without speaking. Then he turned to me and said his father would have been proud. He said my grandfather understood that building was about more than putting up walls and roofs. It was about creating something that would outlast the people who made it. It was about contributing to a world you would never live to see completed. He said I had honored that legacy in a way he never fully appreciated until he watched me fight an entire corrupt system rather than surrender what I had built. I do not think my father had ever told me he was proud of me before that day. We stood there together looking at the building that had cost me everything and given me back more than I knew how to measure. I still live in the third-floor apartment where I moved all those years ago when the building was barely habitable. The plaster medallions still grace the ceiling above my bed. The heart pine floors still glow warm in the afternoon light. The windows still look out over Main Street where other preserved buildings now house thriving businesses instead of the parking structures that would have replaced them. I think about Keisha sometimes and wonder if she ever reads the news stories about what happened after she left. I hope she found whatever she was looking for. I do not blame her for leaving when she did. Nobody should have to watch someone they love pour their entire being into a building for over a decade while the world tries to tear it down around them. The building is open to visitors now, and people come from across the state to see what preservation looks like when someone refuses to give up. I give tours on Saturday mornings and tell the story of how the city tried to take my worthless building and ended up writing me the biggest check in county history. Most people laugh at that part. Some of them cry. All of them leave understanding that fighting for what matters is never wasted even when the odds seem impossible. The Whitmore building stands today because I refused to let corrupt officials destroy it. Not because I was smarter or richer or better connected than the people who tried to take it from me. I won because I was willing to outlast them. Because I documented everything and saved every piece of paper and trusted that the truth would eventually matter. Because I found lawyers and investigators who believed in the cause and fought alongside me when I could barely afford to pay them. Because ordinary people showed up at courtrooms and city council meetings and made their voices heard when it would have been easier to stay home. The building is just bricks and mortar and wood and glass. But what it represents is something more important than any materials that compose it. It represents the idea that ordinary citizens can fight back against power when power becomes corrupt. It represents the value of preserving what came before us instead of always rushing toward whatever is new and profitable. It represents 14 years of my life, and I would do every single one of them again. Thanks for watching till the end. Make sure to subscribe and like to not miss the next story.